Hello everyone, welcome to Let's Crack UPSC CSE English in our NCERT Marathon series. Today we'll continue with Class 11th NCERT Indian Constitution Act work, which will help you to understand concepts for polity if we are talking about optional subjects like public administration or pol science. So friends, specifically oriented for polity session like Indian Constitution Act work, Class 11th NCERT Part 5. We'll see further remaining topics. So before going to start today's session, it's my pleasure to welcome you all on Unacademy, India's largest learning platform, where you will get unlimited access for live and recorded classes, structured courses, and much more. It's me, Rushikesh Inamdar, guiding UPSC aspirants from last 8 years. You can follow me on Unacademy and you can join our Telegram group using this link. Yes, hello everyone. Now we'll start today's session. So it's my pleasure to announce you or inform you that we are conducting UCSC Unacademy Civil Services Championship on 13th June morning, 10 a.m. to 12 p.m. So basically this is scholarship test in which you can enroll free and you will get exciting prizes and scholarships. So in prizes like MacBook, iPhone, iPad and AirPods. So do not forget to participate in Unacademy's Civil Services Championship. We are also providing 4-in-1 offer which we will discuss during the course or during the session today, where you will get printed notes worth rupees 10,000 absolutely free with minimum 1 year subscription, mega subscription offer, chase your dream with Unacademy through no cost EMI benefits, and 10% discount using referral code RBI Live. We will discuss this offer in detail during the session today. Those aspirants pursuing their graduation or after their 12th examination, planning to start their preparation for civil services, it's our suggestion to go with our iconic subscription, where you will get all the features of plus courses like live classes, structured courses, weekly tests and unlimited access for live and recorded classes. Along with these features, in iconic subscription you will get additional features like personal guidance, study planner, material, expert guidelines and test analysis. We are providing plus and iconic paid subscriptions on our platform. Now, here is the benefits for all of you. Like when you will opt for these subscriptions with referral code RBI Live, you will get 10% discount in subscription, which means for 2 years of plus course you have to pay only 68,800 rupees after discount, and in iconic subscription for 2 years you have to pay only 1,04,175 rupees for 2 years subscription. These subscription fees after the discount using referral code RBI Live. Yes friends, we are going to start new batch from 2nd June. You can join regular batches like for 1 year, 2 year. Here is a revision batch also and NCERT batches. As per your convenience, you can join these batches. We are providing free test series for all aspirants. You have to just use code RBI Live to unlock the test. And Unacademy Combat on every Sunday morning 11 a.m. The combat is available in Hindi and English medium. Here also you can enroll yourself using code RBI Live for the Unacademy Combat. So let's start today's session. Indian Constitution Act Work Marathon Series, Part 5. So friends, already we have covered the constitution, why and half, rights in the Indian constitution, election and representation, executive, legislature. So today we'll start with the judiciary. Yes, friends, we'll start with the judiciary. I hope everyone aware about the fundamental duties mentioned in our Constitution of India in part 4A, Article 51A. Whenever you will get time, just go through it. Now we'll start with the Chapter 6, Judiciary. So friends, many times courts are seen only as arbitrators in dispute between individuals or private parties. Now today we are studying first judiciary. So friends, as we are observing or as per our experiences, many times courts are seen only as arbitrators in dispute between individuals or private parties. But judiciary performs some political functions also. So judiciary is an important organ of the government. As we have discussed, the legislature or legislative, executive and judiciary. So judiciary is an important organ of the government, and the Supreme Court of India is in fact one of the very powerful courts in the world. Yes friends, if we are talking about the judicial systems in the world, then the where Supreme Court of India is in fact one of the very powerful courts in the world. So right from 1950, the judiciary has played an important role in the interpreting and in protecting the constitution. Yes, as a democratic country, we are following all principles mentioned in our constitution. So right from 1950, the role of judiciary also important in interpreting and in protecting the constitution. So in this chapter now we'll see or study the role and importance of the judiciary. So in this chapter on fundamental rights, we have already read that the judiciary is very important for protecting our rights. And after studying this chapter today, you would be able to understand the meaning of the independence of judiciary, the role of Indian judiciary in protecting our rights, the role of the judiciary in interpreting the constitution, and the relation between the judiciary and the Parliament of India. So now, first of all, we'll see why do we need an independent judiciary. Yes, first of all, we'll discuss the example when in childhood days we are playing at the ground nearby our house. So like where a group of children playing in the ground, like the age group between 6 to 14 for example, and there are also some children from 18 to 20 age group. So during the playing game, these elder children or the boys, they are interfering the game of 6 to 14 years children, like they are playing cricket for example, and the boys from age group 18 to 20, they're disturbing them, means another group of boys or interfering in their game, like they are changing their rules. For example, basically these elder children playing an umpire's role, or they are changing rule after short of intervals. Now see or understand how those, or how that group between 6 to 14 years can enjoy the cricket game. So there are restrictions or interference from other group. So the group of 6 to 14 years not able to enjoy the game properly. So when we are talking about the independence or independent things, or without the interference, have a separate freedom, or the we can say a separate meaning of the that particular thing. So in a society, the disputes are bound to arise between. Now, come to the topic, like in our society, disputes are bound to arise between individuals, between groups, and between individuals or group and government. So all such disputes must be settled by an independent body in accordance with the principles of rule of law. Now we have to understand the rule of law. So this idea of rule of law implies that all individuals, like rich and poor, men and women, forward or backward castes, and are subject to the same law, which means the rule of law is make sure that everyone treated same before the law. Yes. So the principal role of the judiciary is to protect rule of law and ensure supremacy of law. So it safeguards rights of the individual settles dispute in accordance with the law and ensures that democracy does not give way to individual or group of dictatorship. In order to be able to do all this, it is necessary that the judiciary is independent of any political pressures. Now, what is meant by an independent judiciary, and how is this independence ensured? When we are talking about the independent judiciary, what is it? What is mean by? And how is this independence ensured? Now we'll see. So friends, here one of the good cartoons throughout the NCRT of class 11th we have seen earlier also. So whenever you will get time, you can just see all these cartoons in one go. So they are much talking about the situations described in the book. So now, this is the cartoon given in the judiciary chapter. No fisticuffs please. This is rule of law. So as an eminent lawyer, you ought to know that your action is tantamount to under section of subsection GB and read along with IPC A11B notwithstanding. So this cartoon is talked about the lawyer's discussion in the court. Whenever you will get idle time, just understand the meaning and reread. These cartoons, yes. Now we'll see independence of judiciary. Yes. So, which is simply stated, independence of judiciary means that the other organ of the government, like the executive and legislature, must not restrain the functioning of the judiciary in such a way that it is unable to do justice. The other organ of the government should not interfere with the decision of the judiciary. Judges must be able to perform their functions without fear or favor. Yes. Hello everyone. So today we are studying in our marathon series class 11th NCRT part 5, and the topic is judiciary. So independence of the judiciary, which does not imply arbitrariness or absence of accountability. So judiciary is a part of the democratic political structure of the country. Yes, as we have discussed, friends, judiciary is a part of the democratic political structure of the country. So it is therefore accountable to the constitution, to the democratic traditions, and to the people of the country. So now we'll see how can the independence of judiciary be provided and protected. So the Indian Constitution has ensured the independence of the judiciary through a number of measures. Like, the legislature is not involved in the process of appointment of judges. Yes. Thus, it was believed that party politics would not play a role in the process of appointments. So, in order to be appointed as a judge, a person must have experience as a lawyer and or must be well versed in law. So political opinions of the person or his or her political loyalty should not be the criteria for appointments to judiciary. Yes, friends. So, Indian Constitution has ensured the independence of the judiciary, in which the first measure is that the legislature is not involved in the process of appointment of judges. So the judges have a fixed tenure. Now, another measure is the judges have a fixed tenure. They hold office till reaching the age of retirement. So only in exceptional cases, judges may be removed, but otherwise they have security of tenure. So security of tenure ensures that judges could function without fear or favor. And the Constitution prescribes a very difficult procedure for removal of judges. So the constitution makers believe that a difficult procedure of removal would provide security of office to the members of judiciary. Yes, the constitution makers believe that a difficult procedure of removal would be provide security of office to the members of judiciary. Now, the judiciary is not financially dependent. Next measure is that to perform duties impartially, the judiciary is not financially dependent on either the executive or legislature. So the constitution provides that the salaries and allowances of the judges are not subject to the approval of the legislature, and the actions and decisions of the judges are immune from personal criticisms. So the judiciary has the power to penalize those who are found guilty of contempt of court. So now friends, this authority of the court is seen as an effective protection to the judges from unfair criticism. So Parliament cannot discuss the conduct of the judges except when the proceeding to remove a judge is being carried out, and this gives the judiciary independence to adjudicate without fear of being criticized. Now after that, appointment of judges. So the friends, the appointment of judges has never been free from political controversy. So it is part of the political process. It makes a difference who serves in the Supreme Court and High Court. So difference in how the constitution is interpreted. The political philosophy of the judges, their views about active and assertive judiciary or controlled and committed judiciary have an impact on the fate of the legislations enacted. Then Council of Ministers, Governors, and Chief Ministers and Chief Justice of India all influence the process of judicial appointment. Now we'll understand. As far as the appointment of Chief Justice of India is concerned, over the years, a convention had developed whereby the senior most judge of the Supreme Court was appointed as the Chief Justice of India, and this convention was, however, broken twice. In 1973, A.N. Ray was appointed as CJI, superseding three senior judges, and again Justice M.H. Beg was appointed, superseding Justice H.R. Khanna in 1975. So the other judges of the Supreme Court and the High Court are appointed by the President after consulting the Chief Justice of India. So this in effect means that the final decision in matters of appointment rested with the Council of Ministers, what then was the status of consultation with the Chief Justice? So this matter came up before the Supreme Court again and again between 1982 and 1998. So initially, the court felt that role of the Chief Justice was purely consultative. Then it took the view that the opinion of the Chief Justice must be followed by the President. Yes, friends. And finally, the Supreme Court has come up with a novel procedure. So it has suggested that the Chief Justice should recommend names of persons to be appointed in consultation with four senior most judges of the court. And thus the Supreme Court has established the principle of collegiality in making recommendations for appointments. Yes. So at the moment, therefore, in matters of appointment, the decision of the group of senior judges of the Supreme Court, which carries greater weight. Thus, in matters of appointment to the judiciary, the Supreme Court and the Council of Ministers play an important role. Now, after the appointment, we'll see removal of judges. So, friends, in today's marathon series, we will cover page by page NCERT. It will help you understand the concepts in easiest way. Yes, that's why we're taking in slow speed, the covering NCERT page by page. Now we'll see removal of judges. The removal of judges of the Supreme Court and the High Courts is also extremely difficult. Yes, the removal of judges of the Supreme Court and the High Courts is also extremely difficult. So judge of the Supreme Court or High Court can be removed only on the ground of proven misbehavior or incapacity. A motion containing the charges against the judge must be approved by special majority in both houses of the parliament. Yes. So I hope everyone remembered about the special majority means. So we have covered this special majority in the chapter elections. So now it is clear from this procedure that removal of judges is very difficult procedure, and unless there is a general consensus among members of the parliament, a judge cannot be removed. Yes. Now, with this procedure, we can say that the procedure that remove of a judge is very difficult procedure, and unless there is a general consensus among members of the parliament, a judge cannot be removed. So it should also be noted that while in making appointments, the executive plays a crucial role. So the legislature has the powers of removal. So this has ensured both balance of power and independence of the judiciary. So far, only one case of removal of a judge of Supreme Court came up for consideration before Parliament. And in that case, though the motion got 2/3 majority, did not have the support of the majority of the total strength of the House, and therefore the judge was not removed. So, friends, after the independence, only once a case of removal of judge of the Supreme Court came up for consideration before Parliament. But again, due to this procedure, or the motion got two-thirds majority and it did not have the support of the majority of the total strength of the House, and therefore the judge was not removed. Now we'll see this unsuccessful attempt to remove a judge. So what happened, friends? In 1991, the first ever motion to remove a Supreme Court justice was signed by 108 members of Parliament. Justice V. Ramaswamy, during his tenure as Chief Justice of the Punjab and Haryana High Court, was accused of misappropriating funds. So in 1992, a year after Parliament had started the removal proceedings, a high-profile inquiry commission consisting of judges of the Supreme Court found Justice V. Ramaswamy guilty of willful and gross misuses of office, and moral turpitude by using public funds for private purposes, and reckless disregard of statutory rules. So while serving the Chief Justice of Punjab and Haryana High Court, so despite this strong indictment, Ramaswamy survived the parliamentary motion recommending removal. The motion recommending his removal got the required two-thirds majority among the members who were present and voting, but the Congress party abstained from the voting in the House. Therefore, the motion could not get support of one half of the total strength of the House. So this is an unsuccessful attempt to remove a judge. Yes, friends, now as we have started the topic today, judiciary, we have covered like why do we need an independent judiciary, a system without any interference from legislature or executive. Then we have covered appointment of judges, removal of judges. Now we'll see structure of the judiciary. Yes, friends, now we'll see the structure of the judiciary. So the Constitution of India provides for a single integrated judicial system. This means that unlike some other federal countries of the world, India does not have separate state courts. The structure of the judiciary in India is pyramidal with the Supreme Court at the top, high courts below them, and district and subordinate courts are the lowest level. So friends, the lower courts function under the direct superintendence of the higher courts. So in India, we have a single integrated judicial system. The structure of the judiciary in India is pyramidal with the Supreme Court at the top, high courts below them, district and subordinate courts at the lowest level. Yes, now we'll understand the structure of the judiciary. Yes, so we'll see the structure of the judiciary. Yes, hello everyone. Yes, one of the aspirant joined just now. So friends, today we'll see class 11th NCERT in detail. So we'll cover the topic judiciary. Now we are studying structure of judiciary. So Supreme Court of India at the top. Its decisions are binding on all courts, which means on High Court, District Court and subordinate courts. The Supreme Court of India can transfer judges of High Courts. Supreme Court of India can move cases from any court to itself and can transfer cases from one High Court to another. So Supreme Court at the top of the pyramid, then High Court. So High Court can hear appeal from lower courts, that is from subordinate courts or district courts. Then High Court can issue writs for restoring fundamental rights. High Court can deal with cases within the jurisdiction of the state, and High Court exercises superintendence and control over courts below it like district court and subordinate courts. Then Supreme Court at the top, then High Court, and after that district court at the lower and subordinate courts. So district court, which deals with cases arising in the district. District court considers appeals on decisions given by lower courts, and district court decide cases involving serious criminal offences. So friends, I hope everyone aware about the district court establishment near your district, and then subordinate courts, which considered cases of civil and criminal nature, which is at the base of pyramid. So if we are talking about hierarchy, like at base of the pyramid is subordinate court or district courts, then High Court and Supreme Court. So this diagram is talked about the pyramidal structure of the Supreme Court in India. Now after that we'll see jurisdiction of Supreme Court. Yes friends, the Supreme Court of India is one of the very powerful courts anywhere in the world, and however it functions within the limitations imposed by the Constitution, and the functions and responsibilities of the Supreme Court are defined by the Constitution. So the Supreme Court has specific jurisdiction or scope of powers. Yes friends, jurisdiction of Supreme Court of India. So original jurisdiction, appellate and advisory. So Supreme Court can issue writ of habeas corpus mandamus prohibition, certiorari, and quo warranto to protect the fundamental rights of the individuals, and the jurisdiction of Supreme Court of India, like original jurisdiction, appellate jurisdiction, and advisory jurisdiction. We'll see all those jurisdictions in details. Before that, in short, original jurisdiction, which settles dispute between union and states and among states. The appellate jurisdiction tries appeals from lower courts in civil, criminal, and constitutional cases. And advisory. The Supreme Court advises the President on matters of public importance and law. Yes. Also, Supreme Court has special powers, like can grant special leave to appeal from any judgment or matter passed by any court in the territory of India. Now we'll see in detail original jurisdiction. Yes, friends, original jurisdiction means cases that can be directly considered by the Supreme Court without going to the lower courts before that. So original jurisdiction means cases that can be directly considered by the Supreme Court without going to the lower courts before that. So from the diagram which we have discussed, we'll notice that the cases involving federal relations go directly to the Supreme Court. So the original jurisdiction of the Supreme Court, which establishes it as an umpire in all disputes regarding federal matters. So in any federal country, legal disputes are bound to arise between union and the states and among the states themselves. So the power to resolve such cases is entrusted to the Supreme Court of India. It is called original jurisdiction because the Supreme Court alone has the power to deal with such cases. Neither the high courts nor the lower courts can deal with such cases. So in this capacity, the Supreme Court not just settles dispute but also interprets the powers of union and state government as laid down in the Constitution. So this is the original jurisdiction of Supreme Court. Now we'll see writ jurisdiction. So friends, now after that, writ jurisdiction. In this writ jurisdiction, as we have already studied in the chapter on fundamental rights, which means any individual whose fundamental right has been violated can directly move to Supreme Court for remedy. Yes, after the original jurisdiction, the writ jurisdiction, where a person or citizen whose fundamental right has been violated can directly move to the Supreme Court for remedy. Yes. Mr. Putin, this is the class of NCERT. हम क्लास 11 की एनसीईआरटी पढ़ रहे हैं जिसमें जुडिशरी चैप्टर आज कवर करेंगे. Yes. So original jurisdiction, writ jurisdiction. The Supreme Court can give special orders in the forms of writs. So the high courts can also issue writs, but the persons whose rights are violated have the choice of either approaching the high court or approaching the Supreme Court directly. Through such writ, the court can give orders to the executive to act or not to act in a particular way. This is the writ jurisdiction. Then appellate jurisdiction. In appellate jurisdiction, the Supreme Court is the highest court of appeal. So a person can appeal to the Supreme Court against the decisions of the High Court. And however, High Court must certify that the case is fit for appeal. That is to say that it involves a serious matter of interpretation of law or constitution. Then, in addition, in criminal cases, if the lower court has sentenced a person to death, then an appeal can be made to the High Court or Supreme Court. Of course, the Supreme Court holds the powers to decide whether to admit appeals, even when appeal is not allowed by the High Court. And appellate jurisdiction means that the Supreme Court will reconsider the case and the legal issues involved in it. So if the court thinks that the law or the constitution has a different meaning from what the lower courts understood, then the Supreme Court will change the ruling and along with that also give a new interpretation of the provision involved. Yes, appellate jurisdiction. Now the high courts too have appellate jurisdiction over the decisions given by courts below them, which means by district courts and subordinate courts. After that, we'll see next jurisdiction is advisory jurisdiction. In addition to original and appellate jurisdiction, the Supreme Court of India possesses advisory jurisdiction also. This means that the President of India can refer any matter that is of public importance or that which involves interpretation of Constitution to Supreme Court for advice. Now, however, the Supreme Court is not bound to give advice on such matters, and the President is not bound to accept such an advice. So what then is the utility of the advisory powers of the Supreme Court? The utility is twofold. In first place, it allows the government to seek legal opinion on a matter of importance before taking action onto it, and this may prevent unnecessary litigations later. Yes, and secondly, in the light of the advice of the Supreme Court, the government can make suitable changes in its action or legislations. If we are talking about the utility of the advisory powers of the Supreme Court is twofold. In first, it allows the government to seek legal opinion on a matter of importance before taking action on it, and this may prevent unnecessary litigation later. And secondly, in the light of advice of the Supreme Court, the government can make suitable changes in its action or legislations. Now we'll see Article 137 of the Indian Constitution. We described that the Supreme Court shall have power to review any judgment pronounced or order made by it. Yes, Article 137 of the Constitution empowers the Supreme Court, or which describes that the Supreme Court shall have power to review any judgment pronounced or order made by it. And Article 144, which describes that all authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. Article 144, which describes as all authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. So this is the jurisdiction of Supreme Court, original appellate advisory. So in writ jurisdiction, the Supreme Court can issue writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto, which is to protect the fundamental rights of the individuals. And Article 137, which describes as the Supreme Court shall have power to review any judgment pronounced or order made by it. Article 144, which describes as all authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. So these two articles helps us to understand the unified nature of our judiciary and the powers of the Supreme Court. Yes, Article 137 and Article 144, which help us to understand the unified nature of our judiciary and the power of the Supreme Court. So, decisions made by the Supreme Court are binding on all other courts within the territory of India. So, orders passed by it are enforceable throughout the length and breadth of the country. And the Supreme Court itself is not bound by its decision and can at any time review it. So besides, if there is a case of contempt of the Supreme Court, then the Supreme Court itself decide such a case. Yes, friends. Friends, do not forget to participate in Unacademy Civil Services Championship, which is scheduled on 30th June, where you can enroll yourself absolutely free and win scholarships and amazing prizes worth rupees 3 crores. Yes, friends. In this scholarships and prizes, top 100 to 50 rankers to get guidance by best CSE mentors. Scholarship like 25% to 100% scholarships available. You will get Unacademy study material, that is physical notes, and the amazing prizes like MacBook, iPad, iPhone and AirPods. So do not forget to participate in Unacademy Civil Services Championship. Now friends, we'll see judicial activism. So friends, have you heard the term judicial activism earlier? Or public interest litigation, PIL. Both these terms are often used in the discussions about judiciary in recent times. A number of times we are reading these terms in newspapers as well. So many people think that these two things have revolutionized the functioning of judiciary and made it more people friendly. Yes. Now just see the cartoon given in the book. डाक हड़ताल कोर्ट ने हस्तक्षेप किया और हड़ताल. So do you know that in recent time the judiciary has ruled that the bunds and hardtals are illegal? So judicial activism or public interest litigation, PIL, are the common terms used recently in the discussions about judiciary. So the chief instrument through which judicial activism has flourished in India is public interest litigation, that is PIL, or social action litigation, SAL. Now we'll understand what is PIL or SAL, that is social action litigation. How and when did it emerge? So in normal course of law, an individual can approach the courts only if he or she has been personally aggrieved. So that is to say, a person whose rights have been violated or who is involved in a dispute could move to the court of law. And this concept underwent a change around 1979. So in 1979, the court set the trend when it decided to hear a case where the case was filed not by the aggrieved persons but by others on their behalf. So as this case involved a consideration of an issue of public interest, so it and such other cases came to know as public interest litigations. So around the same time, the Supreme Court also took up the case about rights of prisoners. This opened the gates for large number of cases where public spirited citizens and voluntary organizations sought judicial intervention for protection of existing rights, betterment of life conditions of the poor, protection of the environment, and many other issues in the interest of the public. So PIL has become the most important vehicle of judicial activism. So PIL has become the most important vehicle of judicial activism. Now, judiciary, which is an institution that traditionally confined to responding to cases brought before it, which began considering many cases merely on the basis of newspaper reports and postal complaints received by the court. So, therefore, the term judicial activism became the more popular description of the role of the judiciary. Yes. Now, some early PILs. In 1979, newspapers published reports about under trials. So there were many prisoners in Bihar who had spent long years in jail, longer than what they would have spent if they had been punished for the offenses for which they were arrested. So this report prompted an advocate to file a petition, and the Supreme Court heard this case. So it became famous as one of the early public interest litigations. This was the Husainara Khatun versus Bihar case. Then in 1980, a prison inmate of the Tihar jail managed to send a scribbled piece of paper to Justice Krishna Iyer of the Supreme Court narrating physical torture of the prisoners, and the judge got it converted into a petition. Though later on, the court abandoned the practice of considering later this case, which known as the Sunil Batra versus Delhi Administration 1980, also become one of the pioneers of the public interest litigation. So these are the some early public interest litigations. Now, though the public interest litigation, the court has expanded the idea of rights, clean air, unpolluted water, decent living, etc., are rights for the entire society, and therefore it was felt by the courts that individuals as part of the society must have the right to seek justice wherever such rights were violated. And secondly, through public interest litigation and judicial activism of the post 1980 period, the judiciary has also shown readiness to take into consideration rights of those sections who cannot easily approach the courts. For this purpose, the judiciary allowed public spirited citizens, social organizations, and lawyers to file petitions on behalf of the needy and the deprived. Yes. So these are the judicial activism or public interest litigation. Yes. There is one query from the student. So friends, if you want to attend the bilingual sessions, we have another platform. Also, you can attend these sessions on bilingual as well. Yes. Now, It must be remembered that the problems of the poor are qualitatively different from those which have hitherto occupied the attention of the court, and they need a different kind of judicial approach. If we blindly follow the adversarial procedure in their case, they would never be able to enforce their fundamental rights. This is the statement by Justice Bhagwati in Bandhu, Bandhuha Mukti Morcha versus Union of India 1984. So, judicial activism has had modified impact on the political system. Yes, judicial activism has had manifold impact on the political system. It has democratized the judicial system by giving not just to individuals but also groups access to the courts. Yes. Now, so judicial activism has had manifold impact on the political system, and it has democratized the judicial system by giving not to just not just to individuals but also groups access to the courts. So it has forced executive accountability. So it has also made an attempt to make the electoral system much more free and fair. So the court asks candidates contesting elections to file affidavits indicating their assets. Yes, the court asks the candidates contesting elections to file affidavits indicating their assets and income along with educational qualifications so that the people could elect their representatives based on accurate knowledge. There is, however, a negative side to the large number of public interest litigations and the idea of proactive judiciary. Yes, proactive judiciary. Now, in the first place, it has overburdened the courts. Secondly, judicial activism has blurred the line of distinction between the executive and legislature on the one hand and the judiciary on the other hand. So the court has been involved in resolving questions which belong to the executive. Thus, for instance, reducing air or sound pollution or investigating cases of corruption or bringing about electoral reform is not exactly the duty of the judiciary. So these are matters to be handled by the administration under the supervision of the legislatures. Therefore, some people feel that judicial activism has made the balance among the three organs of the government very delicate. Yes, democratic government is based on each organ of government respecting the powers and jurisdiction of the others. So judicial activism may be creating strains on this democratic principle. Yes. So this is about judicial activism. Friends, Unacademy is providing you a 4-in-1 offer for UPSC Civil Services Examination aspirants. In this offer, you will get printed notes worth rupees 10,000 absolutely free with minimum 1 year subscription, mega subscription offer in which you will get extended validity of your subscription till next preliminary examination, that is preliminary examination of 2022. Then those aspirant facing financial constraint, then Unacademy is providing to continue or start your preparation for civil services with the loan facility, that is we will provide you no cost EMI option for subscription on our platform. So now you can chase your dream with Unacademy and 10% discount using referral code RBI Live. So this is for offer for limited period. Printed notes worth rupees 10,000 absolutely free. Mega subscription offer. No cost EMI option and 10% discount on your subscription. Yes. Now friends, come to the topic of judiciary and rights. Now after that we'll see the new topic in judiciary itself, the judiciary and rights. Next heading. So friends, we have already seen that the judiciary is entrusted with the task of protecting rights of individuals, and the Constitution provides two ways in which Supreme Court can remedy the violation of rights. In first, it can restore fundamental rights by issuing writs of habeas corpus, mandamus, etc. Article 32, and the High Courts also have the power to issue writs under the Article 226. Yes. And secondly, the Supreme Court can declare the concerned law as unconstitutional and therefore non-operational. Yes, the Supreme Court can declare the concerned law as unconstitutional and therefore non-operational, which is mentioned in Article 13. So, together these two provisions of the Constitution, which establish the Supreme Court as the protector of fundamental rights of the citizen on the one hand and interpreter of Constitution on the other. So the second of the two ways mentioned above involves judicial review. Yes, this is talked about judicial review. So perhaps the most important power of the Supreme Court is the power of judicial review. So judicial review means the power of the Supreme Court or high courts to examine the constitutionality of any law. If the court arrives at the conclusion that the law is inconsistent with the provisions of the Constitution, then such law is declared as unconstitutional and inapplicable. So the term judicial review is nowhere mentioned in the Constitution. And however, in fact that India has a written constitution and the Supreme Court can strike down a law that goes against fundamental rights. So implicitly gives the Supreme Court the power of judicial review. And besides, as we saw in the section on jurisdiction of the Supreme Court, in the case of federal relations too. So the Supreme Court can use the review powers if a law is inconsistent with the distribution of powers laid down by the Constitution. Now suppose the central government makes a law which according to some states concerns a subject from the state list, then the states can go to the Supreme Court, and if the court agrees with them, so it would declare that the law is unconstitutional. In this sense, the review power of the Supreme Court includes power to review legislations on the ground that they violate fundamental rights, or on ground that they violate the federal distribution of powers. So the review power extends to the laws passed by the state legislatures also. Now together, the read powers and the review power of the court, which make judiciary very powerful. So in particular, the review power, which means that the judiciary can interpret the Constitution and the laws passed by the legislature. So many people think that this feature enables the judiciary to protect the Constitution effectively and also to protect the rights of citizens. So the practice of entertaining public interest litigations has further added to the powers of the judiciary in protecting rights of citizens. So judiciary and rights. So did you know that the practice of public interest litigation is now becoming more and more acceptable in many other countries? So while many courts across the world, particularly in South Asia and Africa, practice some form of judicial activism comparable to that of the Indian judiciary, and the Constitution of South Africa has incorporated public interest litigation in its bills Bill of Rights. Thus, in South Africa, it is a fundamental right of the citizen to bring before the constitutional court cases of violation of other person's rights. Yes. So, in the chapter of rights, we mentioned the right against exploitation. So, this right prohibits forced labor, trade in human flesh, and prohibits employment of children in hazardous jobs. But the question is, how could those whose rights were violated approach the court? In Public Interest Litigation Act, judicial activism made it possible for courts to consider these violations. Thus, the court considered a whole set of cases, the blinding, the blinding of the jail inmates by the police, inhuman working conditions in stone quarries, sexual exploitation of children, and so on. So this trend has made rights really meaningful for the poor and disadvantaged sections. Now after that, we'll see judiciary and parliament. So apart from taking a very active stand on the matters of rights, the court has been active in seeking to prevent subversion of the constitution through political practice. Thus, areas that were considered beyond the scope of judicial review, such as powers of the president and governor, were brought under the purview of the courts. So, there are many other instances in which the Supreme Court actively involved itself in the administration of justice by giving directions to executive agencies. Thus, it gave direction to CBI to initiate investigations against politicians and bureaucrats. In the Hawala case, the Narsim Rao case, illegal allotment of people pumps case, etc. So you may have heard about some of these cases. So many of these instances are the products of judicial activism. So the Indian Constitution is based on a delegate principle of limited separation of powers and checks and balances. This means that each organ of the government has a clear area of functioning. Thus, the parliament is supreme in making laws and amending the constitution. So, the executive is supreme in implementing them, while the judiciary is supreme in settling disputes and deciding whether the laws that have been made are in accordance with the provisions of the constitution. And despite such clear-cut division of power, the conflict between the parliament and judiciary and executive and judiciary has remained a recurrent theme in Indian politics. So each organ of the government has a clear area functioning. Thus the parliament is supreme in making laws and amending the constitution. So the executive is supreme in implementing them, while the judiciary is supreme in settling disputes and deciding whether the laws that have been made are in accordance with the provisions of the constitution. And despite the description of such functioning or the clear-cut division of power, the conflict between the parliament and judiciary and executive and the judiciary has remained a recurrent themes in Indian politics. So we have already mentioned the differences that emerge between the parliament and the judiciary over right to property and the parliament's power to amend the constitution. So let us recapitulate that briefly. So immediately after the implementation of the constitution began, a controversy arose over the parliament's power to restrict right to property, and the parliament wanted to put some restrictions on the right to hold property so that land reforms could be implemented. Yes, the parliament wanted to put some restrictions on the right to hold property so that land reforms could be implemented. The court held that the parliament cannot thus restrict fundamental rights, and the parliament then tried to amend the constitution. But the court said that even through an amendment, a fundamental right cannot be abridged. So the following issues were at the center of the controversy between the parliament and judiciary. What is the scope of right to private property? What is the scope of parliament's power to curtail, abridge or abrogate fundamental rights? What is the scope of the parliament's power to amend the constitution? And can the parliament make laws that abridge fundamental rights while enforcing directive principles? So while there can be two opinions on the need for the maintenance of judicial independence, yes, the statement by Aladi Krishnaswamy Iyer in the Constituent Assembly debate, while there can be no two opinions on the need for the maintenance of judicial independence, it is also necessary to keep in view one important principle. The doctrine of independence is not to be raised to the level of a dogma so as to enable the judiciary to function as kind of super legislature or super executive. So the judiciary is there to interpret the constitution or adjudicate upon the rights. So the judiciary and parliament we are covering. So during the period 1967 and 1973, the controversy became very serious. So apart from land reform laws, laws enforcing preventive detention, laws governing reservations in jobs, regulations acquiring private property, for public purposes, and laws deciding the compensation for such acquisition of private property were some instances of the conflict between the legislature and the judiciary. So what happened in 1973? The Supreme Court gave a decision that that has become very important in regulating the relations between the parliament and the judiciary since then. Yes, in 1973, the Supreme Court gave a decision that has become very important in regulating the relations between the parliament and the judiciary since then. So this case is famous as the Keshwanand Bharati case. And in this case, the court ruled that there is a basic structure of the constitution and nobody, not even the parliament through the amendment, can violate the basic structure. And the court did two more things. First, it said that right to property was not part of basic structure and therefore could be suitably abridged. And secondly, the court reserved to itself the right to decide whether various matters are part of the basic structure of the constitution. And this case is perhaps the best example of how judiciary uses its powers to interpret the constitution. So this ruling has changed the nature of conflicts between the legislature and the judiciary. As we studied earlier, the right to property was taken away from the list of fundamental rights in 1979, and this also helped in changing the nature of the relationship between these two organs of the government. So some issues still remain a bone of contention between the two. Can the judiciary intervene in and regulate the functioning of the legislatures? So in the parliamentary system, the legislature has the power to govern itself and regulate the behavior of its members, and thus the legislature can punish a person who the legislature holds guilty of breaching privileges of the legislature. Can a person who is held guilty for breach of parliamentary privileges seek protection of the courts? Or can a member of the legislature against whom the legislature has taken disciplinary action get protection from the court? So these issues are unresolved and are matters of potential conflict between the two. So similarly, the Constitution provides that the conduct of judges cannot be discussed in the parliament. So there have been several instances where the parliament and state legislatures have cast aspersions on the functioning of the judiciary, and similarly the judiciary too has criticized the legislatures and issued instructions to the legislatures about the conduct of legislative business. So the legislatures see this as violating the principle of parliamentary sovereignty, and these issues indicate how delicate the balance between any two organs of the government is and how important it is for each organ of the government in a democracy to respect the authority of others. Now see, the cartoon is showing how active the judiciary in trying to curb corruption in public life. So friends, in this chapter, we have studied the role of the judiciary in our democratic structure, and in spite of the tensions that arose from time to time between the judiciary and the executive and the legislature, the prestige of the judiciary has increased considerably, and at the same time, there are many more expectations from the judiciary. Ordinary citizens also wonder how it is possible for many people to get easy acquittals and how witnesses change their testimonies to suit the wealthy and the mighty. So these are some issues about which our judiciary is concerned. So we have seen in this chapter that judiciary in India is very powerful institution. This power has generated much aim and many hopes from it. Judiciary in India, also known for its independence through various decisions, the judiciary has given new interpretations to the constitution and protected the rights of citizens. As we saw in this chapter, the democracy hinges on the delicate balance of power between the judiciary and the parliament, and both institutions have to function within the limitations set by the constitution. Yes, friends. Now, remaining topic we will continue in the next session of our marathon series. Till the time, do not forget to like, share and subscribe Unacademy videos. Stay home, stay safe, take care, thank you.